right, I think we'll go ahead and get started with our luncheon event. Welcome to everyone. I'm Sean Murphy. I'm the president of the American Society of International Law, and it's really a great pleasure to have everybody here, so a big warm welcome. I'm also a professor at George Washington University, and I'm a member of the UN International Law Commission. We have more than 200 registered attendees at this year's research forum, which is very exciting for us because it's hitting an all-time peak. And it's striking that the attendees are coming from roughly 86 institutions, not just around the United States, but around the world. In fact, we've got 18 countries and 5 continents being represented here. So Singapore to South Korea, Ireland to Israel, China to Cameroon are with us this weekend. So it's really terrific. We received about 165 abstracts for proposals for papers that the Society went through, and we selected 72 of those abstracts as ones that we thought merited being presented here at the research forum. So what we've got over the next day and a half is 24 panels that will be presented for us for all of these different panels. I'd like to give a few words of thanks. First, I want to thank UCLA Law School for hosting this year's research forum. In particular, I'd like to thank UCLA Dean Jennifer Nukin, also Jessica Peak, who's the director of UCLA Law's International and Comparative Law program, and has been very instrumental in organizing the forum this year, and also the UCLA faculty and students for pitching in. It's really been a wonderful and warm welcome, and I'd like to actually ask us to give a warm applause for UCLA. Second, I'd like to acknowledge that the American Society has a research forum committee that is the one that has helped make this all happen. On that committee, as co-chairs, we have Victoria Sahani, Kyle Rustiala, and Jared Wong, who's up here on the podium. My deep thanks to the three of you for co-chairing the committee. The other committee chairs were Anupam Chander, Janie Chuang, Mark Drumble, Karen Knopf, and Catherine Powell. So also a deep thanks for all of the work they've done in reviewing and selecting the papers that you're going to be hearing about today and tomorrow. And finally, I'd like to thank the Society's Executive Director, Mark Agras, Deputy Executive Director Wes Rist, who have been instrumental, along with the entire staff of the American Society, in making this research forum come together. Before we begin the program, I'd like to make 2 general announcements about society matters. The first thing is that we have decided where next year's research forum will be located. That was just approved this morning by the Executive Council of the Society, and I want to thank the members of the Site Selection Committee, Janie Chuang, Tim Meyer, and Jennifer Schwessig, who reviewed the proposals received and recommended the institution. The exact dates are not yet set, but I'm very pleased to announce that Brooklyn Law School will be the site of next year's research forum. So keep that in mind, likely a late October, early November timeframe for that mid-year meeting and research forum. Second bit of news is that I'd like to announce that the Society is launching this month an exciting new podcast series. So if you're a podcaster, keep in mind that we will be shooting out news to you about this podcast series. It's going to take a deep dive into international legal issues that are dominating today's headlines, and for that reason we're calling it International Law Behind the Headlines. So an effort to try to give you a deeper sense of some of the key issues that are coming about. The 2 inaugural episodes, which will launch this month, feature 5 top international legal experts who will be answering the fundamental question, is the post-World War II international order being dismantled? Is the post-World War II international order being dismantled? So very exciting podcast series. It will be regularly updated with new episodes. So in due course, a look for that. The hosts for the podcast series are Catherine Amafir and Kyle Ristiala. So with that, let's move to the main event, which is our discussion today. I want to thank Richard Steinberg, who's up here and is a member of our executive council, for helping propose and bring about this panel today. Many, many thanks to you. Jared Wong, one of the co-chairs of the Research Forum and a professor of law at the University of the Pacific McGeorge School of Law, is going to serve as the moderator. So I'll turn the program over to you, Jared.
Thank you so much, Sean. All right. So it's my distinct pleasure to be moderating this very fine panel on current trade developments. Let me very quickly introduce our speakers before giving us a roadmap for this afternoon's discussion. So to my immediate left is Richard Steinberg, who is a professor of law and political science here at UCLA. During the Uruguay round trade negotiations, he worked as Assistant General Counsel to the U.S. Trade Representative, Office of the USTR, as did the other speakers, in fact. Melida Hodgson, who is to his left, is a partner at the New York office, Foley Hoag. Her practice is in international litigation and arbitration. While she was Associate General Counsel at USTR, she litigated international disputes before the WTO and also provided counsel in NAFTA proceedings. Additionally, she was involved in the revision and negotiation of various FTAs, as well as the 2004 U.S. model bid. To my right is Kathleen Clausen, who is at the University of Miami School of Law. She was also Associate General Counsel at USTR, and there she represented the U.S. in international trade dispute proceedings, and also served as a legal advisor for the U.S. in international trade negotiations. So on to today's topic. In a different age, current trade developments would be an innocuous, even mundane topic for those who are not trade law geeks. Today, it's anything but. All right? To survey this, the tumultuous issues that have been unfolding in trade, the panel decided that we would look at three primary developments. Melida will start us off first by talking about the USMCA, the United States, Mexico, and Canada agreement, which replaces NAFTA. After her, Richard will speak to the wobbly status of the WTO, and then, after Melida, Kathleen will instead talk to us about the rash of Trump tariffs. And then Richard will then conclude by talking to us about the WTO. So let's turn then to the first topic of interest, which is the USMCA. On the 30th of September, the US, Mexico, and Canada reached agreement on revising NAFTA, or what Trump, with characteristic grace, called the worst trade deal in history of trade deals, maybe ever. Now, while some aspects of USMCA look entirely different from what would have been the TPP, for example, the ISDS provisions, other parts of USMCA, to the relief of observers, not only track what would have been TPP, but also improve on it. And so Melida will tell us, on balance, whether its contents are in fact as terrible as its name and acronym, UMESCA.
First of all, thank you to the organizers for inviting me to speak here today. I wanted to get a sense of how many of you are familiar with international trade issues, either from having taken a class or if it's something that you deal with on a more regular basis. If you just very generally could put a hand up. Okay, so a smattering and not a bad amount. And one caveat is that I'm not going to talk about all of the USMCA. I'm going to touch mostly on the investment provisions, investment protection provisions, while mentioning in the context of that, as relates to Canada, a little bit, very little bit, about the trade remedies provisions. So what I'm going to do is, as I said, focus on the investment provisions and talk about why are these issues so controversial. Then I'm going to look at sort of a question that many people have had, which is why would Canada do this? That is, sign on to the USMCA. And a concern maybe that others have, which is essentially whether or not this is a new model going forward, both in terms of trade and in terms of investment protection provisions. And then I know we're going to sort of do a little bit of forecasting to the future, Jared. I don't know if I do that now or we do that afterwards.
Yeah, as a panel at the end.
Okay, perfect. So what then is in the USMCA investment chapter or the draft? First of all, of course, this has only been signed. It's going through what is called a legal scrub. As some of you may know, that means that it will sort of be gone through with a fine-tooth comb. Things have changed that are more substantive than just proofreading in past agreements, notably also the TPP before it became CPTPP. So it's possible that things could change again. It's possible that this new Congress coming in will cause the negotiators to refocus or shift some of the, not necessarily shift the provisions, but to look at the proofreading as more of an opportunity to fine-tune provisions. So certainly in the investment arbitration community, there has been, well, anything ranging from dismay, distress, panic about these provisions. I think people need to sort of step back and think about where we were a year or two ago when Trump indicated that there was going to be no NAFTA, actually. And certainly at some point, once that got down to the level of actually negotiating and there was a U.S. trade representative in place, and it became essentially there was not going to be any investor-state dispute settlement, or as we refer to it, ISDS. And that's because it's the whole litany of complaints over time. It has led to foreign companies, essentially U.S. companies, essentially getting insurance from the U.S. taxpayer or from the other members of the agreement, of the NAFTA agreement, in terms of essentially protecting their poor investment decisions. As well as concerns about whether or not it unfairly prejudiced U.S. investors in the United States vis-a-vis foreign investors. So there were a number of complaints, but at least initially a year and a half ago, the concern was that there was not going to be any investor-state dispute settlement. So it's already a better position than that for those who feel strongly that there should be investor-state dispute settlement. So when we look at it, though, what is there? What is it? Well, there is still investor-state dispute settlement for so-called legacy investments involving Canada. So there is still some investor-state protection for Canadian investors. It has not gone away completely. It will only last for 3 years. Now, a lot can happen in 3 years from whenever this agreement actually goes into effect, as we know. A new administration may come along with different policy objectives and feel that there is no need to go that far, or that there's a need to sort of rejigger the agreement. So again, for investors, there is still some legacy protection, or legacy investments have protection and can bring claims for 3 years. Then the agreement that part of the agreement will disappear. U.S. investors in Mexico will get what I refer to as full ISDS for investments in key sectors. So these are sectors that involve government contracts between the Mexican government or some of its entities and U.S. investors only. In particular sectors that probably will not come as a surprise, such as the oil sector, whether it be exploring, refining, transport, the power generation sector, the telecom sector, and the transportation services sector. Again, these are sectors that you would expect there to be a lot of U.S. investment in. And so for those sectors, there will be essentially full chapter protections. And the full chapter of the USMCA, of the investment protection chapter, actually looks a lot like the CPTPP. And again, of course, the United States had worked for years through the Obama administration on the TPP. And so really it was already a lot better from the perspective of those who were concerned about NAFTA. This was already a much more advanced agreement, and so it makes sense that some of that, at least, is retained. Another sector that will have what I call full protection is the ownership and management of infrastructure projects. So things like toll roads, dams, will receive the protection. So again, in a lot of ways, it covers probably the majority of U.S. investment in Mexico. In other sectors, though, whatever they may be, then U.S. and Mexican investors will only get protection for national treatment and most favored nation treatment, and these will be post-establishment. One of the hallmarks of U.S. protections has always been that you would be protected for your efforts pre-establishment, that is, getting your investment set up. That will no longer be the case, at least in this agreement. And key, given the controversy, not only in the United States, but really Mexico has suffered a lot, I think, in terms of awards that affected its regulatory decisions. The protections will only apply to direct expropriation, so that is essentially nationalizations, and not indirect expropriations from where investors challenge regulatory policy with great frequency. There is a requirement of exhausting local remedies. It is about 30 months. It's sort of a complicated formula, but it ends up giving them almost about the same amount of time that exists under current agreements. There is also a provision that requires or that informs tribunals that they cannot order specific performance, and that is that it cannot tell a state, the tribunals cannot tell a state to, for example, repeal an administrative determination or to undo any kind of legislative action. I am curious as to whether or not that provision actually was meant to be broader than that, or will be expanded to be broader than that in light of a decision by a recent tribunal, the Lago Agrio decision against Ecuador, in which a tribunal has essentially told Ecuador to tell its courts not to enforce its own judgments. And I think that was very controversial, particularly for civil society groups, not least states. So my second question was, why would Canada accept this? My colleagues will speak more about some of the more specifically trade-relevant concerns. But one thing to remember is that there was an agreement between Canada and the United States, a trade agreement before NAFTA, and there actually was no investor state in that agreement. In the mid-2000s, when the U.S. negotiated with Australia, there is no investor state dispute settlement in that FTA. So it's not unheard of for the United States to not have these kinds of provisions necessarily, because at the end of the day, it's a part of a trade agreement, and it depends on what you're getting and for either side. But in my view, what was key for Canada was that it got perhaps something more important in a way, or at least before a recent U.S. court decision more important, and that is the trade remedies chapter. And I'm not going to go into a lot of detail about that, but this affects obviously the ability for an importer to bring an importer who wants to challenge the determinations by an investigating authority, that is, for example, the U.S. Commerce Department in the United States, which imposes duties for what it feels is improper behavior by an importer that is selling, so-called dumping, selling a product or a good in the United States for less than that it's actually worth, in a sense. In the trade remedies chapter, Canada gets certain things. I mean, I think one of the problems with the anti-dumping provisions in NAFTA have always been that, frankly, the United States has obstructed its functioning. It has not always agreed to the formation of binational panels to resolve or hear these disputes. In other ways, it has made it difficult for the panels to issue decisions. It has also not necessarily abided by those decisions. So Canada gets a binational panel system that, with a lot of provisions to ensure that the panels will be formed. For example, there is a provision, an article called Safeguarding the Panel Review System. There's also a sort of a two-tier review system set up that will allow consultations initially, and then could go to a special committee if the consultations don't work out. And as part of that, a state, most likely Canada, could suspend benefits. And so, in my view, this was more important to Canada than having the ISDS provisions. And when you think about some of the trade disputes between Canada and the United States, frankly, the issues over softwood lumber, to the extent that anybody here is familiar with that, it really predates the actual formation of the United States as a country. And so for Canada, these were very important provisions. They did not want to lose those provisions. And so at the end of the day, they gave in other areas, they gave up certain things in order to be able to preserve and have, or not only preserve, but have what they believe will be a sort of fully functioning review system. One of the keys to the new system is that the importers will actually have to go to this system as opposed to domestic courts. And that has always been an issue domestically in the United States because various sectors of U.S. The legal community in the United States were concerned about the fact that you had essentially a group of lawyers, commercial lawyers, making determinations that could, and I guess in some instances had been different from what a U.S. court, organized under the Constitution of the United States, would have determined. So in some senses, this was a trade-off that was worth it for Canada. I made a reference earlier to whether or not Canada may actually believe this is the best deal. We saw, I think it was yesterday actually, that a court in the U.S. had determined that the Keystone Pipeline could not go ahead. This was a big issue, as we knew, starting from the from the Bush administration through the Obama administration. When Trump came in, he basically threatened them and said, okay, you go ahead with this claim, and you'll never get your pipeline. And so some sort of deal was worked out. I think some wondered whether or not it was a very strong deal, but at any rate, now a U.S. court has told Keystone that they cannot go ahead. And so I would suspect that will be a legacy claim that will get revived. And so, at least in the future, however, after the legacy claims provision expires, a Canadian investor would not be able to bring that kind of claim, which is certainly something that the Trump administration wanted to achieve. So is this a new model? No. I think in in a way, the answer to that is it's trade stupid, or it's international trade stupid. Just like the economy was key to an election, we're going through, and this will be discussed more, a time when this is a focus of this administration. It's very specific to the two closest, at least physically, trading partners. I think Canada economically is actually the most important trading partner for the United States, and certainly the United States is for Canada. And so it's very specific, in my view, to the needs at this time of the United States. And so I don't think it becomes a new model, but it may be that other agreements going forward are negotiated more closely with a more close alignment to very specific needs than maybe following a model that perhaps sometimes had to be followed because it was the model and you didn't want to create issues, as opposed to fixing the model more specifically in each instance. So I'll stop there.
Great, thank you, Melinda. I think I definitely agree with you that Canada came out ahead with regard to dispute settlement provisions in the USMCA. I think it's also worth noting, right, that as between the US and Canada, because both are obviously developed economies with very robust court systems, ISDS is not going to be as crucial. It's also important to note that Canada, right, and Mexico will have no ISDS as well under the USMCA, which might be a concern, right, except that they're both parties to the CPTPP, which does provide access to ISDS. And so, there's really no loss to Canada on these fronts. I do think, however, that the 30-month exhaustion period will be a cause of concern for investors that will potentially increase the costs of resolving the disputes significantly. But I should turn to both Kathleen and Richard to see whether they have any comments or questions about the USMCA that they might want to speak to.
Sure, just briefly, and thank you so much, Jared, and to ASIL for the invitation. I'll just pick up on two things Melida said. Actually, the first thing I wanted to say was I really think the biggest winner in the entire negotiation here has to be USMCA.org, which, if you look at it, is the United States Motorcycle Coaching Association. So congratulations to them. Big uptick in traffic on their webpage. So speaking to what Melida said about the need for the legal scrub, I think it's clear that the rush around which Canada was added has meant that we're seeing continuing negotiations now, even if those negotiations are not getting as much press as maybe they otherwise would, because there will be more work done on this legal scrub than there would be in a number of other trade negotiations ordinarily. So USTR folks still going to Ottawa and Mexico City in these weeks in the lead up to the signing. One other area that a number of us were watching was the labor and environment chapters and what we would see in those. And I'll just say a bit about that. The reason we were watching those chapters was because they were critical to the bipartisan deal that has made it possible for a number of trade agreements to get through Congress and Congress's Trade Promotion Authority process. That is, having enforceable labor and environment provisions was something that Democrats historically had insisted upon. And all of that was called into question last year with the conclusion of a case between the United States and Guatemala involving the labor chapter of the CAFTA DR, the Central American Free Trade Agreement, in which the United States had sued Guatemala about its failure to effectively enforce its labor laws, but then lost the case subsequently when the panel, although concluding that Guatemala did fail to effectively enforce its labor laws, it hadn't done so in a manner affecting trade, which was the key language that the CAFTA DR and all of our trade agreements actually include. And so, of course, it was no surprise that labor and environment did come in to the new NAFTA, to the USMCA. But what was perhaps also unsurprising, but perhaps disappointing, was that that language was not actually fixed. Instead, we see what we see throughout the agreement was a number of footnotes being dropped with the words "for greater certainty," which really, if someone has not yet written an article on "for greater certainty," someone should, because we see that instead of being able to fix ambiguous language or perhaps even language that's not helpful to the United States, we're just dropping these footnotes to make more ambiguous language about what those words might mean. So I think the question now is, with the flip in the House, whether it is time for a new bipartisan deal on better language, if that the political capital is now there, or if we're going to continue to live with for greater certainty.
I think we could easily consume the entire time discussing just the USMCA. Melita focused on ISDS, which is an important component and deserved quite a bit of time. I want to just expand out on this just a little bit about understanding the economic impact of this agreement, which in short isn't going to be very much. It really looks very, very similar to NAFTA. There are a few modest changes, and those changes in many ways will benefit basically the red states that supported Donald Trump. So, to cover some of those very briefly, automobile rules of origin, and rules of origin basically define the content, the percentage of the content of a product that needs to originate in North America in order to give that product duty-free treatment in North America. We, in this agreement, increased the automobile rules of origin from 62.5% to 75% content. This basically means that for cars made in the North American production network to continue to get duty-free treatment crossing North American borders, they're going to have to use fewer auto parts from Asia. Also, and of course that is a throw out to the upper Midwest, which Donald Trump won in 2016. The automobile, the minimum wage in automobile production there will now be an automobile minimum wage of $16 an hour on at least 30% of content, rising to 40% of content in a year. This is also something that will benefit auto workers largely in the upper Midwest. Combined, they will probably make the U.S. auto industry less competitive. So we may have actually a decline in auto sales, but of course, I'm sure Kathleen's going to talk about the possibility of high tariffs on automobiles. We'll have also, Canada is going to allow in 3.6% of its market in dairy. That is going to help Wisconsin and Vermont. Again, states that supported Trump. There will be a reduction, basically, there's a grading standards issue on wheat, and that is going to become non-discriminatory. That will help the wheat states, again, red states. So overall, we haven't had a CGE, computable general equilibrium model projection of the overall economic effects of this deal. My guess is that it will be that the economic benefits will increase by less than 1% over the economic benefits of NAFTA, which is a very, very small number. So it's a small number, but many of the constituencies that will benefit from it are Trump supporters.
Great, thank you, Richard. And I'll now turn this over to Kathleen, who will talk to us about the terrifying tariffs, including the controversial Section 232 and 301 tariffs that the Trump administration has imposed.
Great. Okay, so all of the tariffs in 15 minutes is the goal. Obviously, the tariffs have been the focus of, I think, most of the rhetoric on the trade war. That's really largely what folks are talking about. So I'm going to focus on 3 sets of tariffs, which I sort of refer to as the 3-digit sagas. They're the 3-digit sagas because they derive from 3-digit tariff statutes. So the first one is Section 201, 3 digits. Section 201 of the Trade Act of 1974. In short, this statute permits the president to take action to facilitate a temporary positive adjustment, we call it. So tariffs or quotas for an injured industry. Basically, there's an emergency situation for a domestic industry and something must be done to correct, to allow that industry to compete successfully. So last November, that's a year ago, 2017, After the filing of 2 petitions from industry members, the U.S. International Trade Commission, which is a quasi-independent agency, found that imports of solar panels and washing machines had caused such an injury to those U.S. industries that it recommended that President Trump impose global safeguard restrictions. We call them safeguard restrictions. So President Trump imposed tariffs to the tune of $8.5 billion, covering an $8.5 billion worth of imports on the solar cells and $1.8 billion of washing machines. So that's saga number 1. Saga number 2, Section 232 of the Trade Expansion Act of 1962. That one has gotten a lot of press. This is the statute that permits the president to pose restrictions on imports that threaten U.S. national security. So in April of 2017, President Trump instructed the Commerce Department to initiate investigations into whether steel and aluminum imports threatened U.S. national security. The Commerce Department carried out those investigations and did conclude that they did so threaten. So President Trump then imposed tariffs on these products from all over the world, beginning in March 2018. Now, some of those tariffs have shifted for some countries to quotas. Don't need to get into those technicalities at the moment, but they are worldwide, almost, steel and aluminum imports. Saga number 3, Section 301 of the Trade Act of 1974 is the basis for this third set of tariffs that are imposed on products coming in from China. So the other 2 I've talked about are those on specific products, specific industries. This one's on a number of different products, very long list, coming from China alone. So this statute permits the president to authorize any appropriate and feasible action in response to an act, policy, or practice that's unreasonable or discriminatory and that burdens or restricts U.S. commerce. So last year, the Office of the U.S. Trade Representative carried out an investigation in which it concluded that China is engaged in such acts, policies, or practices as they relate to technology transfer, intellectual property, and innovation. So President Trump then imposed tariffs on a wide range of products in different phases, beginning in July of this year, when the third phase, now the third list, has come out and been implemented in September. That is the longest list of products. It covers a number of consumer goods, and that the rate on that long list is 10% now on for those tariffs, but that will increase on January 1st to 25% unless a deal is reached. So that's the general overview of what's occurred within the executive. There are a few other skirmishes to which Richards has already referred. 232 investigations, that is the national security investigations going on with respect to the imports of autos and auto parts. There were side letters on the USMCA regarding future potential auto-related national security tariffs for Canada and Mexico, sort of giving them a grace period to negotiate something if the United States decides to move forward on those tariffs. There's also a 232 investigation ongoing on imports of uranium. And then it was just rumored yesterday, I think credibly rumored, that there could be another Section 301 investigation coming from USTR that focuses on China's labor practices, which then would permit yet more action against China. And I think there's no doubt that even though these measures are, many of them, global in scope, for the most part they are targeting China. And a number of those folks in the room have already spoken about how this creates somewhat of a, I said trade war before, whether there's a Cold War with China. Now, are we in it? Are we on the brink of it? Someone has referred recently to an iron curtain of tariffs. Now, so the vocabulary remains of the war variety. Another thing that's not in doubt, to my mind, that's perhaps complementary to the China piece, is the diversity of approaches from each of these executive agencies. And so you have USTR on the one hand, Commerce, and the ITC. ITC sort of is only responding to what's coming in to it, but at least between USTR and Commerce, there seems to be a significant clash in view on how they should be approaching U.S. trade policy, a lack of communication, maybe a more diplomatic way of putting it, or a competitiveness over what each of them has as a bit of a shiny tool that they can offer to the president to do what he wants to do. And so I think that's exacerbating some of our situation, and particularly so with the WTO issue that we'll hear more about from Richard in a moment. Ambassador Lighthizer, the U.S. Trade Representative, has referred to our new period as having a paradigm shift, and not entirely clear what he was referring to, but at least I would say that the paradigm shift is referring to this reuse of these domestic statutes after some period of euphoria over multilateral institutions in recent years and the lesser use of these domestic statutes. But it's clear that Ambassador Lighthizer believes that the multilateral tools are simply insufficient for addressing the China threat and possibly other threats. They're insufficient to address the grievances that are coming from his base as well as the president's base more generally. But I think as I and others have said, it's going to take more than tariffs to achieve those goals. It's not clear that there is a longer-term plan from USTR or from the executive more generally, especially not one that takes into account all of the retaliation that has resulted. But I'll come back to those responses in a moment. It seems that perhaps a better approach, or at least something that should go hand in hand, would also be the use of domestic tools to address the internal distribution of wealth problems that may be fueling some of these tariffs. A number of commentators have also claimed that, at least with the 232 and the 301 tariffs, that they're largely pretextual, that we're using these domestic tools as a justification for something that is clearly a violation of international rules, some sort of power play. I'm not sure that's entirely the case for the 301. I do think there is a legitimate concern about what China is doing and potentially a legitimate legal position that what they're doing cannot be addressed through the multilateral rules. We can talk about that more if you wish. But it is true that even if we do get a successful result out of the 301, that is, even if China does drop these barriers to trade that it has in place, the IP licensing and so forth, and therefore opens its market more to U.S. investors, that is in tension with the president's other goal, it seems, to have U.S. producers actually stay here in the United States rather than go to China. So there's clearly some tension there, but I'm not sure, again, I think it's just clearly not all the way thought through. But it is clear that some of these tariffs seem to either violate in whole or in part or come very close to violating WTO rules, and that's led to a number of criticisms in Geneva. So let me speak to those. But just before turning to those responses, I'll just say a bit about whether this is old wine in new bottles, right? Have we used these tools before? Well, the answer to that is yes, many times, but not recently, right? That's the issue. So the 201, we've used Section 201 more than 73 times in the last 40 years. Relief has been granted 26 of those 73 times. The 232, there have been 26 investigations in our country's history under the 232. A negative determination has come 62% of the time, and action was only recommended 5 times. Those all dealt with oil back in the day when we were more concerned about oil. And then the Section 301 has been used more than 120 times in the last 50 years. Of course, it's difficult to sort of take these numbers into account as compared to what's happening now, because some of them can be initiated by industry, so it's not necessarily always the president taking this action. But the China was the target of 301 in the early 90s. In the 80s, the focus was on Japan. So there have been a number of times that we've seen these tensions arise before, so it's really nothing new in that respect. But let me then just mention the responses in brief to keep you apprised of those. Many of you know the response by our trading partners has been to impose retaliatory tariffs on us. So we are seeing a number of those from the traditional partners you would expect, and then some you may not expect. Also, a number of countries bringing cases at the WTO regarding each of these tariffs, and we can hold our discussion on whether or not those will be successful until we hear from Richard. And then, of course, these are being used as leverage, as we've already heard in the NAFTA context and beyond, to get deals from our trading partners that we might not have gotten otherwise. Response from industry. Well, a number are not happy, as you've heard. Many of them are seeking exclusions. So there is a process by which, at least for the 232, you can try and have your products excluded from the tariffs because you need them as inputs into whatever you're making in the United States. And so there is a bit of process working through the Commerce Department where you can apply for exclusions. But there have been complaints that those processes are opaque, difficult to access. But it's even worse for the 301, where 301 exclusion requests were granted, at least by the end of October. Despite more than 4,000 of them having been reviewed at some threshold level by the executive, 500 of them denied. And then there was an announcement that the latest list, I said the longest list of tariff products that came out in September, there will be no exclusion process for that. And so you have members of Congress asking USTR to reconsider that decision. We have one industry member challenging the constitutionality of the Section 232 of the statute that is under the non-delegation doctrine, saying that there is delegating too much to the executive without a constitutional check. I think commentators believe the likelihood of that being successful is low, but we'll see. They're in a summary judgment hearing coming up in December. And also some APA challenges making their way through, not as many perhaps as some of us expected, but I think many are waiting for the constitutional challenge to go through first. And then Congress. Congress is responding. There are more than 12, bless you, there are more than 12 bills working their way through Congress. I say working their way, I think that's probably an overstatement. I'm not sure they're doing anything. But there are 12 bills that have been introduced in Congress to rein in the delegation to the president. Some attention has been given to some by Corker, Porter, Sanford, all of these trying to create a mechanism by which Congress could actually issue a joint resolution of disapproval or require a joint resolution of approval before the president could move forward. Some of us have talked about other options that would give more authority to the Department of Defense, for example, in the national security context, an actual repeal of these, better language. Again, for all of these congressional responses, the biggest problem is the veto. Right? And then we are not going to overcome the veto in challenging and trying to change this language and take back some of that delegation to the president. So what's ahead, I'll just say a bit now, and we can talk more if time permits, but it may not permit. So I'll just say a bit now. That is that there is word that Canada and Mexico are in conversation with the United States about the 232 tariffs, the national security tariffs, and how to get out of that. Trudeau has said it's not going to be a problem to get through the new NAFTA, despite that these tariffs are in place, though there's pressure to be a little bit stronger, I think, on that he is facing. There's also discussion that we are close, the president said we are close to a deal with China. Not entirely clear what that means, but certainly that threat of the new China 301 investigation seems to be a way remember that was the one that they're talking about doing to deal with China's labor practices. That seems to be a way to get Democrats on board for the new NAFTA. So these all go hand in hand. All three of us are working interchangeably on all of these issues. The WTO cases will proceed slowly. As I said, we're going to face some problems there that Richard will discuss. Could it get worse? Absolutely yes, but let's hope for the best, and I'll stop there.
Great, thank you. I think on the charge that these tariffs are pretextual in nature, it's not just the relative dormancy, right, of the tariffs that are involved, it's the severity and the breadth. I mean, as of this time, I think something like $250 billion worth of Chinese products are targeted by these tariffs. But Richard and Melida, do you have anything to add to this discussion of tariffs?
You know, I mean, I think there's concern about the Section 232, and you look at this like it's this really a national security issue, but maybe it is like the caravan at our border right now. So I think that's a legitimate concern. You know, something that Richard said earlier actually about the auto rules of origin, dairy, and wheat. It's true. It's definitely targeted towards the Trump base. But I will say that these are issues that have been longstanding with Canada. You know, cases have been brought at the WTO about these issues, and there's been complaints about the rules of origin. You know, and one interesting juxtaposition is the fact that they were able to sort of peacefully change the rules of origin requirements with Korea without much. I mean, I think there were a lot of people who felt that, or some former negotiators who felt that the rules of origin provisions had just gotten out of hand, and that when NAFTA was done, certainly no one was really thinking about China in the background. And I think one of the interesting things that is even in the investment chapter, and I cannot find my greater certainty footnote on this, but there is a provision that basically refers to an investor not really being an investor if that investor is controlled by a non-party, by a investor from a non-party state. So it is about China. It is about people who felt that the WTO deal with China and other things, other subsequent agreements that did not sufficiently address the threat of China. And so, you know, Trump is reaping the benefit of that, but I think there were always concerns about that and whether or not the United States had been sufficiently strong in its negotiations with China.
Okay, I think just in the interest of time, I'm looking at the clock. I will yield my time on offering any comments on this right now. Will reference it to some degree in my remarks.
Okay.
Broadly.
And I'll just quickly note that in relation to targeting China, the USMCA provides, right, that if any of the state parties enters into an FTA with a non-market economy, which is conveniently defined to include China, that the other parties can terminate USMCA and enter into their own bilateral agreement. There's no question that that certainly targets China. But Richard, please talk to us about the WTO.
So the GATT-WTO system is becoming increasingly dysfunctional. While the legislative system has been dead there for more than a decade, the judicial system has continued to operate, but now, and this is the most important new development at the WTO, the appellate body will soon cease to function, and with that, the dispute settlement system will de-judicialize. The question is why? Well, at one level, the U.S. government, and implicitly the voters who elected Donald Trump, believe that the WTO is no longer a useful forum for multilateral negotiation of trade rules, and that it is no longer in U.S. interest for the WTO dispute settlement system to operate as a judicialized system. But the WTO's problems run much deeper than that. The fundamental problem is actually structural. The problem is that trade negotiating power is now so dispersed in the multilateral trading system that little can get done there. So I want to unpack this, first talking about the political economic context behind this slow demise of the GATT-WTO system, then talk about why the legislative system is dead, and then talk about why the dispute settlement system is de-judicializing. And this de-judicialization of the dispute settlement system, by the way, I will note, is a topic of increasing conversation among scholars. Kathleen has a good piece coming out. Greg Schaefer has an excellent piece coming out. And Karen Alter here has some work coming out on just the general idea of de-judicialization. So I want to talk first about this domestic and international political context in which all this is happening. First, domestically, right? Trump's election, Brexit, other elections in Europe represent clear dissatisfaction with the social changes that have evolved along with global liberalism, liberalization. We know, of course, that trade liberalization leads to aggregate benefits for national economies, and trade liberalization in the post-war period has been very good for the U.S. economy. But we also know that it has distributive consequences. In our case, the case of the U.S., opening our market has meant greater competition for unskilled and semi-skilled labor who just can't compete with foreign labor at $1 an hour. The United States has ignored this problem for decades. We have not dealt with the distributive consequences. We haven't adopted policies for those left behind, and the chickens have come home to roost. This is exactly what Donald Trump was appealing to. He was appealing to those who have been hurt by liberalization and those who fear that they may be next. At the same time, what's happening internationally, I think, is of deeper importance, and that is that U.S. negotiating power to develop new rules to open foreign markets, which would help labor and would help business in the United States. Our negotiating power has declined. So negotiating power in a trade negotiation is the ability to open your market more to others or to threaten to close it. And the problem is that our power has declined. So let me, I'm assured that all I have to do is press the, yes, okay. This is share of GATT-WTO GDP of key members. The U.S. share of GATT-WTO GDP is in blue. The European Union is in this sort of amber color. China is in yellow. You can see the coding here, okay? If we go back to 1947 when we created the GATT, the United States produced 75%, it's right after World War II, everything's bombed out, 75% of what would be GATT GDP. We therefore wrote the GATT, presented it to the rest of the world, and said, if you want access to our market, sign here, okay? That's a lot of bargaining power. You can see that our bargaining power has declined precipitously. By the mid-70s, we couldn't get anything done in the GATT without the Europeans. This culminates with the establishment of the WTO in 1995, when US and European GDP account for roughly 60% of GATT WTO GDP. And so what did we do? We actually withdrew from the GATT 1947 and created a legally distinct but essentially verbatim identical instrument, the GATT 1994, joined that, and if anyone wanted access to our markets, the US and Europe, they had to sign on to that agreement and had to sign on to all the other WTO agreements, many of which developing countries said they'd never sign on to, right? So there's nothing in it for developing countries to sign on to TRIPS or to GATTs, okay? So we forced them, we used our bargaining power to force them on board. What's happened more recently, though, since 2000, is that the power has dispersed, right? So China is obviously the biggest factor in the equation. It's the rise of China, but it's the BRICS combined, Brazil, Russia, India, and China, which now we bargain with, but their interests, particularly China's interests, are divergent from ours, and we really just can't get anything done. So that has made the legislative process, the process of making new rules at the WTO, essentially irrelevant. From 1947 to 1994, we had 8 successful trade rounds that dealt with all sorts of new issues as they came up. Since 1995, we haven't successfully concluded any, and the one round we've tried has failed. So our multilateral rules to deal with the digital economy, biotech, and other new technologies, those are antiquated, and more importantly, there's an absence of meaningful multilateral trade law to address a long list of frictions created by the scale and the form of the Chinese economy. We have nothing that really deals effectively with state enterprises, which account for about 30% of the Chinese economy, nothing to deal with state-owned banks, nothing to deal with state-led cyber theft of trade secrets, nothing really effectively to deal with forced tech transfer, nothing to deal with state-supported consumer boycotts. So what's happened is that as these trade strategies have emerged, these foreign trade strategies have emerged, and technology has advanced, we are seeing larger and larger gaps in international trade law, which are now chasms, huge areas that just aren't covered, okay? So briefly, consider an old industry, steel overproduction, right? So China is producing massive amounts of steel below cost by state enterprises. The banks are, state-owned banks are carrying massive amount of debt, and that debt is building. The result is that steel ends up being injected into the global market. The world price for steel falls, and that hurts American industry. And there's no remedy in WTO law to deal with that. We can impose anti-dumping and countervailing duty measures on the stuff coming into the U.S., but we can't do anything about the third country markets. Consider now the new industries. China's made in China 2025 strategic plan will use subsidies, protection, and is using state-led cyber theft of trade secrets to become the global leader in high-tech industries such as biotech, pharmaceuticals, artificial intelligence, and robotics. So now we are losing jobs not just in low-skilled and unskilled areas, which is what Trump tapped into, but in what economist Paul Krugman calls strategic sectors, those with positive externalities and high rents. We're talking about high-tech areas that have been the drivers of the U.S. economy and high-tech areas that are crucial to defense technologies. And this is happening in the context of increasing geostrategic tension with China, particularly in the Western Pacific. WTO rules give us no existing rules to fully address these new issues. And because of the dispersion of power in the WTO, we have no capacity to legislate these new rules. This now is crucial background for understanding the de-judicialization of the WTO. And make no mistake, we are on a clear path to de-judicializing the WTO, shutting down the appellate body. And the way this is happening is it requires a consensus to appoint new appellate body members, which is, for those who don't do trade, like the Supreme Court of Trade. The U.S. has been blocking that consensus. So through attrition, we are down to a critical number of appellate body members. It requires 3 appellate body members to take a decision, and we will fall below 3 members in December of 2019. At that point, the appellate body will cease to function, and the dispute settlement system at the WTO will not perform as intended. So why are we doing this? What's the logic or the reasoning of the administration? The first is that without a functioning legislative system, the appellate body is facing a docket of cases that demand clarifying ambiguities and filling gaps to deal with some new issues. And this puts enormous pressure on the appellate body because every time it clarifies an ambiguity or fills a gap, it is creating rules that would have been created through negotiation. It's catalyzing displeasure from at least some WTO members. Second, and related, without a legislative system functioning, there is a debilitating constitutional flaw in any system. So in a successful national judicial system, you need a legislative system to check and balance decisions by the court system that are found to be politically unacceptable. And here, in the WTO, without a legislative check, the appellate body has engaged in very expansive lawmaking, some would say activism. There are powerful legal underpinnings to make an argument that the appellate body should have an expansive approach, that they should fill gaps and clarify ambiguities, but there is an equally powerful jurisprudential stance which says that the appellate body should be deferential and restrained. In this view, the appellate body and the dispute settlement system was designed to primarily apply the rules. And so there's a provision in the dispute settlement understanding that says the appellate body cannot add to or diminish the rights and obligations in the WTO agreements. You would interpret ambiguous provisions as allowing a range of behaviors that fall within the ambiguity, and as reflecting an agreement to disagree on a more specific limitation. We can, well, if we had more time for Q&A, we'd get into this in great detail. But this is a stance that tends to resonate more with countries like the U.S. And the U.K., which are sort of fiercely protective of their sovereignty, where we rarely give direct effect to treaties, where it's unthinkable that an international court decision could enjoy supremacy over a later in time statute or the Constitution. So this concern is something that we've been raising, the United States has been raising for 20 years. It affects both procedure and substance. And without going into huge detail on substance, what I will say is that the lawmaking by the appellate body has been very expansive in the area of trade remedy laws, the anti-dumping laws and countervailing duty laws and safeguards laws that are the very laws that are designed to be a political safety valve for example, the constituency that Trump has appealed to, those who have been hurt by trade. So in the view of the administration, the appellate body has fundamentally shifted the balance of rights and responsibilities in the WTO. And third, without the legislative function operating, we now have these giant chasms in trade law. And the problem is that puts the United States in a difficult position, right? So take state-led cyber theft of trade secrets. We can either do nothing, or we can take China WTO dispute settlement. We would lose because there's no clear rules against it, right? Or we can act unilaterally. And one of the things that 2016 showed was we just can't sit there anymore and take this. We've got to move on to another path. We don't have as complete a set of rules really as we need in order to have a highly judicialized system. I will just end because of time by noting that when we agreed to a highly judicialized system in the Uruguay round, our position, and I went back to the now unclassified briefing book of the U.S. government, quote, to even consider a judicialized system, we need strong GATT rules in all areas. In 1995, we had strong GATT rules in in almost all areas that were known at the time. We don't anymore.
Thank you, Richard. Because of time constraints, can I suggest that the panel move on to a general discussion and that Kathleen and Melida fold in any comments you have to Richard's comments in speaking to that. So if you look at these three developments in broad strokes and you simplify, you might say it looks like global trade regulation is fragmenting with the WTO being dysfunctional, and when there is any kind of solution, it happens on a bilateral or regional basis, for example, through USMCA. Whereas investment is actually going in the opposite direction. It was born in the world of BITS, but in fact, we're now seeing a world where there are multilateral investment agreements. And so my question to the panel is this a permanent paradigm change, right? Or is this an aberration because of who's in office? And regardless, right, is there anything that can be done while the trade administration is in the driving seat?
Well, I'll start by going on a limb and saying that I hope that who's in office is an aberration. And I do think that the particular policies that are being followed, that there could be other policies be followed. We have, so we're bounded by the structure of the system. We're bounded by the great difficulty of legislating, if you will, within the WTO system. But I think there are great opportunities to act almost completely multilaterally without China by working with our like-minded countries to put pressure on China and to expand trade and investment, working with territories like the European Union, Japan, Canada, Australia, sort of other OECD-type countries.
So I agree with a lot of what Richard has said. I think that the issue with the WTO and the appellate body is, and again, to me, this predates Trump. I think it started in the Obama administration, actually, to sort of the first sort of going, wait a minute, what's going on here with these, some of the decisions that basically had not been agreed to during negotiations, and the appellate body was determining that this is what the rules meant. So again, it began before that. I'm not actually convinced that we're going to a more multilateral world, at least not in investment. I actually think it's much more regional and actually bilateral. And I remember in the 2000s when the U.S. started to do these regional agreements, whether it be CAFTA and the originally there was an Andean agreement, then it had to be split up because of issues in Latin America. And TPP is sort of that regional. And I think it's a sort of a little bit of feeling of maybe being burnt, or just sort of realistically thinking that a multilateral is just not really possible because they're going to have too many actors. And once you start to expand, there was I can't remember the acronym now, but there was a few years ago an IP agreement under the auspices of the WTO negotiation that began, and it began with like-minded And eventually, everybody wanted to join it, and it kind of fell apart, and it was not ACTA, I think it is, and actually became less than it could have been to the extent that it's anything today. So I actually think that's where we're going, and of course, as a single entity, you have more power than as part of a dispersed group.
Just briefly, I agree with all that's been said, and going back to my earlier comments, at least some of this seems cyclical, right? And so I think, but what's most concerning is the lack of plan. And that it's clear that we're using these tools, but then we're treading water. Ambassador Dennis Shea, our ambassador, USTR's representative in Geneva, said recently in an interview, we want things how they used to be, but where are all the proposals? Why is nobody proposing reform? It's a very convenient position for him to take, that we know what we want, but nobody else is proposing reform. Meanwhile, the EU and Canada, at least in the WTO context, have started to think about reforms, but they're not particularly responsive, and they have a number of flaws. So I think holding decision makers accountable is a problem in all areas of international dispute settlement that often leads to exit. So far, we don't have that. We might have an opportunity then for reform.
Wes is going to kill me because the next session starts at 2:15, but I think I'll take 2 questions, and then maybe we can disperse from there. Greg?
Okay. So it's great presentations. A lot of people, Richard explicitly, put his finger on the competition with China. Do you see a fundamental shift from seeing international economic law from an economic perspective, in terms of efficiency and so forth, to a strategic and national security one? And if so, then that's going to mean that in the long term, there's going to be, or for the foreseeable future, there'll be a very different role for international law and international institutions in this field.
Why don't we take the second question too? Yes, go ahead. Who is it?
Possibly a bit related, but thinking about the U.S. withdrawal from TPP, and I know that in the USMCA, there were incorporated many provisions of TPP. What do we think of that decision now at this point, especially in relation to the issues we face with China?
Well, in my view, the USMCA, that should have been where NAFTA should have gone, because that was TPP is a better agreement, and it addresses a number of things. Part of the complaint about TPP is that it didn't sufficiently deal with how China is able to get under the skin, let's say, of these agreements, and it didn't have provisions, for example, like the provisions you have in USMCA about whether or not there's a non-market economy behind the scenes. And so that is, I think, from the point of view of those who are very concerned about China, that's a problem with TPP. But in a lot of ways, some of the at least in investment, I think, some of the sort of day-to-day complaints about NAFTA and what it said or didn't say, or directions that it didn't have, transparency even, those were addressed in TPP. So I don't think it's so bad, but.
Very brief. I'll just speak to Lucinda's question. I agree again with Melida. I do think that this was a great way for the Trump administration to claim credit for everything that the Obama administration negotiated, to the extent those pieces made it in to this agreement. But they also clearly could get some deals that they couldn't have gotten in with TPP because of the other number of parties that were there. So you can see that very clearly in, for example, the labor chapter. There were some things there that Malaysia or Vietnam surely would not have agreed to. So to that extent, small win.
So I'll respond first to Greg's question. I think that the economic and geostrategic drivers are dovetailing. Yes, trade is efficient, right? But when one of Krugman's points was that when you're talking about losing strategic sectors, then actually the math changes, and it might not be beneficial. You add to that the distributive issues that are faced by an open trading relationship with China, and we have a serious economic problem. Clearly, the geostrategic issues are of great importance. I've actually been surprised that more hasn't been made of it in both the popular press and even in journals like Foreign Affairs and Foreign Policy. I just want to note that I agree with Kathleen, though, that a unilateral approach to China is doomed to failure. This is not, our model, and Lighthizer model seems to be Japan 1980s. This is not Japan in the 1980s. China is much bigger and much more secure and growing. In terms of Lucinda's question, I'll have a chapter on state enterprises, for example. We ought to have as broad a number of countries as possible sign on to that. Obviously, Mexico, it's not a big problem in U.S.-Canada, U.S.-Mexico-Canada context, right? But this is precisely the kind of new rules that I think we need to address and get our other trading partners, like-minded trading partners, on board with, such as OECD members.
And with that, we'll have to close the session, unfortunately. Please join me in thanking our speakers.